Jury trial or judge alone, your choice changes everything.
One critical decision can completely change the outcome of a criminal case, and many people don't even realize they have a choice. When facing criminal charges in California, you generally have the right to choose between two types of trials: a jury trial, where a group of your peers decides your fate, or a bench trial, where a single judge serves as both the legal authority and the fact finder. This isn't just a procedural formality, it's a strategic decision that could significantly affect the outcome of your case. In a jury trial, 12 members of the community are selected to hear the evidence and render a verdict. For a conviction to occur, all 12 jurors must agree. Unanimity is required. This means that even one juror holding reasonable doubt can prevent a conviction, which can result in a mistrial. Jury trials are guaranteed by the Sixth Amendment of the U.S. Constitution for serious criminal charges, but you can choose to waive this right under certain conditions if you believe another path might be more beneficial. A bench trial, by contrast, eliminates the jury altogether. The judge alone hears the evidence, applies the law, and makes the final decision about guilt or innocence. The procedure mirrors that of a jury trial. There are still opening statements, the presentation and cross-examination of witnesses, and closing arguments. But instead of persuading a group of people with different backgrounds and perspectives, your case is being evaluated by a single legal professional. In California, while most defendants have the right to request a bench trial, the prosecution must generally agree for the request to be granted. There are several key distinctions between these two types of trials. First is the decision maker. In a jury trial, the outcome hinges on the collective judgment of 12 individuals. In a bench trial, only one person holds that power. Second is the decision maker's background. Jurors are ordinary citizens who may be influenced by emotion, intuition, or gaps in legal understanding. Judges, on the other hand, are trained legal experts who are familiar with evidentiary rules, procedural issues, and nuanced legal principles. Third is timing and efficiency. Bench trials tend to be faster. There's no jury selection, fewer procedural delays, and the trial itself is typically more streamlined. Lastly, the strategic presentation of a case varies. Some arguments are better suited for a jury's sense of fairness or empathy, while others rely on legal technicalities that are more effective in front of a judge. So how do you know which is right for your case? A jury trial may be the better option if your case involves emotionally compelling facts, sympathetic character evidence, or a narrative that resonates with common sense and community values. When all 12 people must agree to convict, it provides an added layer of protection against a wrongful conviction. Self-defense cases, for example, or cases involving misunderstandings between parties often fare better with juries who can relate to real-world dynamics and human behavior. On the other hand, a bench trial might be more suitable if your case involves highly technical or legally intricate issues, such as financial crimes, procedural defenses, or evidence that may be overly complex or confusing for a jury. If there's a risk that a jury might react emotionally to certain types of evidence, such as allegations involving sensitive subject matter, a judge may be better equipped to separate emotion from fact. Bench trials are also often chosen when a swift resolution is desired, as they typically move faster through the system. Choosing between a bench and jury trial is not a decision that should be made without serious consideration and legal guidance. The best choice depends on the specifics of your case, including the nature of the charges, the complexity of the evidence, the personality and reputation of the assigned judge, and even the characteristics of the local jury pool. It also depends on your own background, demeanor, and how your story might be perceived differently by a judge versus a jury. Once made, this decision is binding. Waiving a jury trial cannot usually be reversed later. Timing is also critical, as the request must be made before the trial begins. This decision could be one of the most consequential choices in your defense. It requires thoughtful analysis, legal insight, and a strategic approach tailored to your unique circumstances. The goal is not just to have your day in court, but to choose the court that gives you the strongest chance of success. Understanding the difference between a bench trial and a jury trial is essential for anyone involved in the criminal justice process. The choice can significantly impact the outcome of a case, and it's not one to be made lightly. If you found this information helpful, please subscribe to our channel for more legal insights and practical guidance. For those facing actual charges, we invite you to schedule a confidential consultation with our office. Our experienced team is committed to helping our clients make informed, strategic decisions along the way. Visit the link in the description to get started.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.